I guess we start in about 3 minutes. There's no one here. Okay, then let's get started. Hi everyone, welcome to today's Supreme Court live update. We'll be covering two cases from today for you. One is the ongoing Constitution Bench case on whether the Group of Companies Doctrine should be read into the Arbitration Act 1996. The second case that we'll be dealing with is with a short update on the Gyanvapi Mosque case. But we'll get to that towards the end of the video. To start off with, Solicitor General Tushar Mehta came up today and said that the Group of Companies Doctrine, which is a doctrine to include non-signatories in arbitration proceedings, even if they have basically parties, even if they have not signed an arbitration agreement, whether they can be brought into the arbitration proceedings because they were involved in the transaction or the dispute in question. Solicitor General Tushar Mehta, in what is a interesting development where he is on the same side as his regular opposition in senior advocates Kapil Sibal and A.M. Singhvi, he argued in favor of the doctrine as well. He argued that the doctrine was necessary in order to make the Arbitration Act effective and functional, because the doctrine ensures that disputes aren't fragmented into multiple different proceedings, which is an objective of the Act as well. He said that he specifically referred to Section 7 and the fact that the Section 7 defines an arbitration agreement and says that there is no need for a contract in order for an arbitration dispute to take place, and that even the word parties is left undefined. All that's required is an established legal relationship between two different parties for the group of company for those two parties to be involved in an arbitration together. There can be an agreement. It has, even in the situation where an agreement does exist, it has to be examined through the lens of that phrase. that phrase of not requiring a defined legal relationship. And so after that, he argued that even if the court found that that Section 7 did not expressly recognize that the Group of Companies Doctrine, that the legislature, when they were making the act, did not envision the Group of Companies Doctrine when they were doing so, the court still has the power to read the doctrine into the act, even if it's silent on it. Because in this instance he referred to a United States judgment where he said that as long as where the court held a United States judgment that I believe was referred to by the Delhi High Court, and the Delhi High Court approved of its bearing in Indian law. They said that as long as there isn't a section in an act that specifically excludes the doctrine, such as the Group of Companies Doctrine, it can still be the court can still read that doctrine into the act to fill in certain gaps that they may find. After he argued, senior advocate Darius Khambata came, and he did not argue against the Group of Companies Doctrine so much as he made submissions to limit and temper the Group of Companies Doctrine, make sure it's like his definition of effectiveness was different from Tushar Mehta's. While the Solicitor General focused on making sure that the doctrine Tushar Mehta's submissions focused on making sure that disputes didn't get fragmented, whereas Darius Khambata's submissions were in favor of making sure that all the parties who were a part of the arbitration proceedings gave their consent to being a part of the arbitration proceedings. Now, he argued that the doctrine, he referred to a lot of international law. He referred to the Dow Chemicals judgment. He referred to the Dow Chemicals. And in making references to these international sources, he argued that the doctrine only applies when every single party in the arbitration dispute has given mutual consent to being a part of any arbitration proceedings that arise from a dispute. He said that in order for a third party to become a party to an arbitration dispute, they have to have had played a crucial role in the negotiation of the contract, the performance of the contract, and the termination of the contract. In these cases, the contract is referring to the arbitration agreement. At this point, the bench asked Mr. Khambata, why are you referring solely to an arbitration agreement through a contract when Section 7 clearly states that it doesn't have to be contractual? And Mr. Khambata drew a line. He said that while the dispute may not have to be contractual, the arbitration agreement at the end of the day has to be written and therefore will always remain a contract because there is mutual consent and there is performance following it. So the dispute does not have to arise from a contract, but the arbitration agreement remains a contract in that situation. He also spoke about how, as a contract, there needs to be a very, very strong and legitimate reason to bring a third party in. So, as I just mentioned, there needs to be they need to have played a crucial part in negotiation. They need to have played a crucial part in the performance of that contract, and they need to have, if this applies, they need to have played a crucial part in how that contract was terminated. That is the larger sum of what happened in the Group of Companies Doctrine case today. In other news, in the Gyanvapi Mosque case, it was briefly mentioned before CJI Chandrachud and Justices Narasimha and Pardiwala today morning. Currently, there are multiple disputes going on with regards to the Gyanvapi Mosque case. For a little bit of background for anyone who isn't familiar with the case, a group of petitioners approached a court in Uttar Pradesh claiming that the Gyanvapi Mosque at one point housed a shivling, and that Hindus should be allowed to enter the mosque and pray there. Whereas the board of the mosque is claiming that the Places of Worship Act 1991 does not allow the religious character of a place of worship to be changed post 1947. So allowing Hindus to come and pray here would be changing that religious character. So currently there's a pending dispute in the Varanasi District Court that in the district court, the judge has on May 17, 2022, the district court dismissed an application from the masjid board that claimed that the suit from the Hindu worshippers who claimed that there used to be a shivling at the mosque was not maintainable. The court dismissed that application, and there is currently an appeal going on in the Allahabad High Court with regards to that. The other pending dispute is before the Supreme Court right now, where today the petitioner is approached and asked the court to consolidate all of the disputes and all of the pleas into one case so that it can all be heard together instead of having a multiplicity of proceedings. The court said that they would hear that plea on the 21st of April 2023. And that is SCO's live update for today. Visit the